Good afternoon, everybody. Um Here today lecturing on the student and the institution and its relationship to those students. This is among probably the next couple lectures will be among the most important in terms of substantive knowledge regarding what many of you want to do in your careers as it concerns student affairs. So I'm going to cover this in some detail and certainly feel free to ping me with questions if those arise. Thank you thus far. Obviously, as I said at the outset, um, the online teaching is new to me, and I am doing my level best again to put things together in a way that is alien or certainly new to me. So I want to start with, um, again, a bit of history. Student affairs and the relationship of the institution to the students, going back really to the outset of higher education in this country, and certainly during the 20th century up into the 1960s, um, saw a situation or an environment where the world of higher education was viewed largely as a privilege, and the students were viewed as second class is too strong, but certainly they were subject to the whims of the institution. Students, when they left their homes and went to an institution of higher education, moved into a situation where the school became what was called in loco parentis, which is Latin for local parents. And that prevailed, that philosophy prevailed into the late 1960s, at which time, with the situation in the world at large regarding issues involving civil rights, freedom in Eastern Europe, um, certainly Vietnam, and political upheaval played a role, as well as the first generation of baby boomers to be going off to school in vast numbers, saw the beginning of the transition from um, a higher education being a privilege into a situation where the students begin to demand rights as consumers of a product. Now that there was a following the 70s, there was a bit of retrenchment by the institutions in the 80s and early 90s, but we have seen certainly in the last 30 years a continued growth of student rights being widely recognized in ways that would have seemed very novel prior to 1965 or so. As we think about this, the first case that I would point to is Dixon versus Alabama State Board of Education, and that's a 1961 case. And in that situation, the court rejected the notion that education in state schools is a privilege to be dispensed on whatever condition or conditions the state, in its role, deems advisable, and it rejected the in loco parentis doctrine. The holding in Dixon then, or when I say holding, just so you're aware, I'm referring to the court's decision, the court's ruling in a way that establishes a rule of law. So a court's holding establishes a principle of law that is binding within that jurisdiction where the court sits. So, for instance, the United States Supreme Court has jurisdiction over the entire United States and its territories. The Indiana Supreme Court has jurisdiction over the state of Indiana, etc. So the holding in Dixon then became part of um, Supreme Court jurisprudence with Tinker versus Des Moines School District, Healy versus James, and Goss versus Lopez, which are going to be covered in later sections. Tinker, just for your information, is a First Amendment case that involved the wearing of black armbands by high school students at the Des Moines School District, I think during the late 1960s. And in that case, the school system suspended those students and disciplined them. The U.S. Supreme Court issued a holding that students do not check their First Amendment rights at the schoolhouse door. That's one of the famous lines from that case. And in not checking their rights at the schoolhouse door, as long as the act, the expression under the First Amendment, in this case wearing a black armband is a form of protected political expression, as long as that's not disruptive to the educational process, then those rights are protected and the student should not be subjected to discipline. So the impact of those cases in the public setting, state schools or state-supported institutions of higher education, then morphed and have increasingly also covered private educational institutions. And the courts have viewed the students as contracting parties. So they have rights as a consumer under express and implied contractual relationships with the institution where they've chosen to go to school, and so that both institutions, whether they be public or private, are bound to follow institutional policies, rules, and regulations that govern the relationship between the institution and their students. So, for instance, if the university fails to follow a specific policy as it governs student behavior and goes outside that policy and implements a disciplinary action for something that maybe is outside the scope and intent of the written policy, the student would then have a viable contract claim against the institution for breach of contract. So that is a fundamental and significant change from where we had been prior to the decision in Dixon, and that has continued to evolve, as I say, over certainly the last 50 years with a minor retrenchment in the 80s. And then at about the same time, I believe in the 1970s or so, Congress enacted the Family Educational Rights and Privacy Act, or FERPA. I suspect many of you are familiar with FERPA. It's also known as the Buckley Amendment, after the senator who I believe is one of the sponsors out of New York. Ironically, it's William F. Buckley's brother, Jim Buckley, from the state of New York. And it gave post-secondary students, college students, rights that were independent of their parents. For instance, if a student wants to keep their grades confidential from their parents, they can do so and expressly have to consent to the disclosure of those certain information to their parents or any other person, which came as I think, a significant shock, and still comes as a significant shock to many parents who may be footing the bill for the majority of many students' college educations to find out that they don't have immediate and complete access to records of their child. And I, in spite of the fact that FERPA has been the law in this country for now approaching, we're getting close to 50 years, certainly 40, we still have parents who routinely don't understand that FERPA creates this set of rights for students that have independence from the parents' rights. And you had at the same time a lowering of the age of majority. Certainly voting rights moved from 21 to 18, and 18 was then became a prevailing age of majority in the majority of states as states passed those statutes doing the same thing. The other development at this same time has been a recognition of the students' academic freedom. In the whether or not the students are learning and are obtaining the education for which they're paying has become a much more salient issue than it was even a very brief time ago. Now, turning back to the question of contracts between the institution and the student. An interesting early case, which will no doubt illustrate, if nothing else, the significant change in times that have occurred over the last 50 or so years, is Carr versus St. John's. That's a 1962 case, which is really the foundation for contract claims. It's a New York case, and New York cases oftentimes were a cornerstone for the rest of the country at that time. And in that institution, there was a rule, apparently, that students could not participate in a marriage ceremony or a civil marriage ceremony. I assume St. John's, I know that St. John's is I believe it's a Jesuit institution, and it's a private institution, and the court construed the student's dismissal for having participated in a civil marriage ceremony pursuant to the university's rules, and indicated that there was indeed an implied contract between St. John's and the Carrs, and that if the university complies with those terms, he or she will obtain the degree which is sought. But in this instance, the institution's decision to apply and dismiss these students was sustained because, in the eyes of the court, the students in this case had failed to adhere to the university's prescribed terms, and that Carr principle has been applied to public institutions as well in the succeeding decades. The issue of contract in the world of higher ed is a little different than it is, say, when you're buying a house or a car. Courts give significant deference to institutions in framing their requirements, particularly academic. They give a lot of deference to select and interpret their own contracts terms and to change those terms periodically from time to time with adequate notice. And, the court in a case, I believe 2011 or so, indicated that an institution is clearly entitled to modify its regulations as to properly exercise its educational responsibility. So institutions are not subjected to the same rigor in contract law as a commercial business would be. A commercial business is a much less flexible approach to interpretation of contracts, and some commentators will even call contracts between students and institutions a form of quasi-contract or almost contract, completed or created by law for reasons of justice without regard to expressions of offer and acceptance, which you would typically see in a contract, meaning that for a binding contract you have to have an offer and an acceptance, and at that point it becomes binding. In the world of higher ed, it is effectively an implied contract. There is an offer of admission, I suppose, an acceptance of that offer of admission, and then an agreement whereby the student agrees to be bound by the terms and conditions of the institution as it's held or set forth in the student handbook or other rules and regulations associated with the institution. In spite of the deference that courts have shown to institutions as it concerns contract, it has created a source of litigation rights for students, particularly where we have faculty, administrators in disciplinary proceedings who fail to follow those policies. Most commonly, again, looking back to the principles that I lectured on recently, if there's a due process violation, meaning that there's not notice or an opportunity to be heard, or there is a situation where the institution has behaved arbitrarily or capriciously, meaning they really fully deviated from their policy without good reason. It was on a whim. In that instance, courts have held universities to